Red ink across the board today. Dow's off nearly 700 points. There are just 5 or 6 stocks which account for almost all of that loss. S&P's down 0.69% and the Nasdaq's down 0.69%. Red ink all over. The social media addiction trial resumes today. YouTube's Vice President of Engineering, he's going to take the stand. Ashley Webster's outside the courthouse for us. Ashley, what is YouTube's argument in this trial?
Well, Stu, YouTube believes that it's an entertainment center rather than a social media network. Completely different, they say. And to make that point today, taking the stand will be Christos Goodrow. He is head of engineering at Google, also head of search and discovery at YouTube. Essentially, Goodrow is the man who oversees the algorithms that determine content and recommendations based on viewers' viewing habits. Now, plaintiff attorney Mark Lanier is going to question Goodrow about how those algorithms are designed to keep users engaged as long as possible and whether young viewers are specifically targeted using autoplay features. Now, Lanier has accused engineers of using what he calls behavioral techniques to trigger dopamine hits, turning the platform into a digital casino. YouTube argues, no, it is an entertainment platform, more so than a social network, and in this case, they claim the data involving the plaintiff in the case, known as Kaylee, shows that she spent little more than a minute a day on the platform and was not addicted. Once Goodrow is dismissed, whistleblower Brian Boland will retake the stand. He spent more than a decade at Meta working on marketing and advertising and has stated that Mark Zuckerberg is laser focused on profit and growth, but not particularly user safety. Earlier this week, or I should say in the recent days, we spoke with Frances Haugen, one of the original whistleblowers who worked at Meta. This is what she had to say. Okay, apparently we do not have that. Let's move on. The trial is seen, though, Stu, as a bellwether for some 1,500, 1,600 other trials and how those trials will be resolved. We're also expecting to hear from the plaintiff herself, who is now 20 years old. We know her as Kaylee, or KGM. She is expected to take the stand sometime this week. But the trial is far from over. And one more point, Stu. It's going to be 81 degrees today, so it's going to get a little hot around here. Back to you.
You couldn't resist it, could you, actually? You know perfectly well that we're in the middle of a blizzard here in New York, so you just had to rub it in that you're out in the sun. We'll see you next.
You would have done it too, Mr. Varney.
Yes, I would have. That's true. Thanks, Ash. All right, let's bring in former Deputy Assistant Attorney General John Yoo. John, thanks for being with us today. From what you've seen so far, how do you think this trial's going? Who's winning?
I think this is a case that's going to have to go up on appeal, and maybe even the Supreme Court will have to decide. I'm sure the facts will show that the social media companies in some way contributed to the harms that the plaintiff and other young boys and girls are suffering from being addicted to social media. But there's going to be an important legal question, which is, do we hold the networks responsible for the content that you can see on their screens? For example, if someone defrauded you, Stuart, out of your life savings from Nigeria, do we allow you to sue the phone company? No, we don't allow the communication networks themselves to be liable. But if these social media companies are specifically and intentionally designing products to be addictive that go beyond just the content, then we may hold them liable as a society. And I think that's really going to be up to the courts and the Supreme Court. I wish Congress would actually sit down and settle this rather than thousands of trials all throughout the country. But that may be where we're left if Congress doesn't take action.
Got it. President Trump just posted this. I'm quoting now. As president, I do not have to go back to Congress to get approval of tariffs. It has already been gotten in many forms a long time ago. So they were just also reaffirmed by the ridiculous and poorly crafted Supreme Court decision. John, is that right? He doesn't need to go to Congress?
He is right, because past presidents have already gone to Congress. What the court did in Learning Resources on Friday was just strike down the kind of blanket, universal, instantaneous tariffs passed under an emergency statute. But there are much more specialized, discrete statutes which explicitly give the president the power to impose tariffs, but he can't do them worldwide and permanently all at the same rate he did last year. He has to, for example, explain, why is this country a national security threat? Or why does this country engage in unfair trade practices if he wants to use these other statutes? So they have to be much more targeted. There have to be facts behind them. He probably can't impose tariffs on countries, for example, we have trade surpluses with, or that are NATO allies that don't pose a national security threat.
Yeah. The government might have to refund $175 in tariffs that's already been collected. Trump says that's going to take years and years of litigation. Is he right?
It could be the mother of all refunds. Yeah. I mean, I already wait months for the IRS just to get my income tax refund. How is the Commerce Department going to set up a whole refund system they never had to before on this scale? Because we never had worldwide tariffs like this before. So I think there's going to be years it takes some people to get tariffs. Maybe importers who paid duties and they have proof, they'll get more immediate refunds. But I agree. I think it could take years for the system to get up and running and for people to get their checks back. You and me, Stuart, consumers like us, I don't think we'll ever get any kind of refunds.
It's a lawyer's charter. That's what we've got going here. John, you, a lawyer. You're all right, though. Thanks for joining us, John. We always appreciate it. Thank you.
Thanks, Stuart.